When I first joined the British Domestic Security Service a very long time ago in my mid-20s in the 1970s, it didn't really occur to us, particularly at that time, that there was a significant tension between civil liberties and what we were doing. In fact, we rather saw ourselves as being the protectors of civil liberties. We thought that information that we gathered about individuals was, of course, absolutely sacrosanct, should be protected by all possible means, but the fact that we were collecting that information didn't particularly occur to us as something that any individual might object to. We were looking for people who were trying to harm the state, of course, and we reckoned that in collecting information about people who were suspected of having done so, we were protecting the state and indeed not affecting anybody adversely who was not a threat to the state. And if we were asked that perennial question, quis custodia ipsus custodes, or who should be the guardians of the guardians, as it were, we would say, well, we can manage that. Our recruitment methods, the vetting procedures we went through were sufficient to ensure that the people who joined would be upright and obvious and natural defenders of civil liberties. And I can sympathize with you if you say that was an extremely arrogant position to take. And it was an arrogant position to take, and it was one that reflected a great deal of self-belief. But we did think that we were looking at the individual for the benefit of the mass, rather than looking at the mass to identify the individual. And it was a completely different world then, of course, in the 1970s. Data was quite hard to accumulate. It wasn't a question of just putting in a name into Google search or something. It took a lot of time and quite a lot of effort, and therefore one certainly didn't want to waste the time and resources for looking for information that wasn't of value. And indeed, if it was found that something was not of value, we would get rid of it. And I think that was one of the default positions, to stamp a file or some papers NFI, which meant of no further interest, and it would go to the shredder. And in fact, it may surprise you to hear that the security service in the United Kingdom wasn't even avowed. It wasn't governed by any legislative statute before 1989, relatively recently, and a long time after I joined. But our targets in those days, of course, were extremely different from those that the colleagues face today, whether here or in the United Kingdom or anywhere else. And essentially what we were looking for were the actions of state actors, the actions of states that were trying to penetrate the security of our own state rather than of individuals or non-state actors. And it was really our attempting to protect the security of the state through protecting the secrets of the state, and that was an attitude generated, of course, over the years of the Cold War. I guess we reckoned that the Russians had an interest in what we were doing, and a desire to find out what we were doing, perhaps rather in excess of the reality. But nonetheless, that's what we thought, so that's what we did. And I think certainly there was an apprehension in those days in some quarters that the state was intruding on the privacy of the individual. Of course, there was George Orwell and all the other literary examples of thought police, and clearly anybody looking at the deep state or the secret state would suspect that there were people who were interested in what people were thinking and doing without any real good reason or rationale. But the services were very small. Very few people were members. Their power was very limited. Their role in government was not particularly significant. And there was a general public acceptance that this was an appropriate function for a state organization, even if that function wasn't embraced with wholehearted enthusiasm. Nonetheless, it was accepted, and for so long as no scandals erupted, it was okay. And the scandals that did erupt, of course, were when spies were discovered who hadn't been discovered earlier, rather than that people were discovered
prying on their fellow citizens without due cause. So there was an issue there of tension between security and privacy, but it was one that really existed below I would say, the level of general consciousness of the public. And that remained the case till later in the 70s and in the 80s, when domestic terrorism really began to take over, dominate the work of the security service, particularly, of course, with Irish terrorism, but also with Palestinian terrorism and other forms of terrorism which grew at that time. And I think that advent of terrorism, so that the risks to society became more apparent than from some poor benighted fellow in the Ministry of Defense who happened to have got compromised by the Russians and was selling him secrets about submarines that were all too quickly outdated. I think that increased the acceptability and tolerance of some measure of intrusion into the lives of the public. But it also, I think, created a divide between a group of people on one side who the state was seen to be trying to protect, and a group of people on the other side who the state was clearly seen to oppose. And the issues behind Irish terrorism and Palestinian terrorism attracted sympathy and support way beyond, of course, the acts themselves. So the issues did resonate with people, even though the acts did not. And that, again, began to bring this idea of tension between security and privacy more into focus. And that, of course, became even more the case as the campaign, particularly against Irish terrorism, progressed in the United Kingdom, with detention without trial and with a dirty war that sort of emerged, albeit not sanctioned by the state, suspected by many to have some involvement of the state, where Protestant groups were attacking Catholic groups in Northern Ireland itself. And I think that began to erode this sort of general understanding that there was a contract, albeit unwritten, between the security services and the state that put civil liberties of the majority at the forefront. So the state was identified as more interested in the civil liberties of one group than another, I think that the legislators and the courts got more interested themselves in thinking, was there sufficient oversight of what the services were doing? And that, I think, was a very healthy reaction. It wasn't a critical reaction, though of course it was seen as such. It was a reaction that legislators should have when they consider what may be going on in a world which is not immediately transparent to them. And I think the security community, on the whole, welcomed that interest of legislators and courts in its activities. I think that the acts of the anti-state group, if you like, had eroded civil liberties to a certain extent, in our view, and that we thought that this should be put on the table, as well as the fact that maybe the civil liberties of that group had been eroded by us. And this wasn't a clear, sort of seen as a clear balance between the civil liberties of one and the civil liberties of another being equal and indivisible. It was seen more as a competition. It was, in many cases, seen as a sort of war of life and death rather than a war of values. Not saying that was right or wrong, but that was how it came out. And the tension, I think, changed further as the threats of terrorism developed. And as those threats became less and less associated with states or state interests and more associated with belief or ideology. And the world order, as the world order began to be challenged by groups that didn't want to just adjust balances of power so much as overthrow the scales themselves. But when the challenge to your values is more obvious and clear, I think then you yourself are perhaps more interested in questioning those values and their validity. And I think that's certainly also what happened. And the tension that existed then between security and privacy tended to grow in proportion to the threat that existed to the values of society as a whole. The awareness of the tension didn't, of course, necessarily lead to a different approach, but nonetheless, it in some way restricted, I think, the sense that action had to be urgent and immediate. Action had to be urgent and immediate, obviously, to stop terrorist attacks, but it also had to consider what was at stake. And I think when Edward Snowden gave his great dump of all the NSA secrets, he revealed the consequences of that new tension, of the way that the tension had risen to the point where the intelligence services would say, well, we need to collect as much as we possibly can, but we should be very, very careful not to abuse it. If you have nothing to hide, you have nothing to fear, this sort of argument. And I think that what he did by revealing the extent to which the collection of data had intruded into people's lives, or could do, was to question that, well, we're not going to abuse it, maxim. Well, okay, you say you're not going to abuse it, but how do we know that? And what do you mean by abuse, and what do we mean by abuse? So in the United Kingdom, and indeed here, of course, the courts and the legislative bodies have introduced controls that have created a much better and more healthy environment for the collection and use of private information, because people are much more aware of the sensitivities of the public at large, and aware that as public servants they should take those into account. But technology, of course, leaps ahead, and technology allows you and tempts you to do things which may not be legislated, may not be regulated. And therefore this tension comes back again as to, well, it may be okay to do that, it's not forbidden to do that, and anyway, again, we are going to be the guardians of our own morality. I think it's absolutely natural that the security world always wants more in case it could be useful in the future, whereas perhaps the civil liberties people always want the collection to be less. And I think that this whole idea of metadata, which is a big argument now in the United Kingdom, whether the government should compel telephone companies and others, for example, to maintain the metadata of a call, that is, who called whom, from where and when, rather than the content of the call, because that's an extremely valuable tool of investigation, but nonetheless is an invasion of liberty, of privacy to a certain extent. Well, I would also say that one of the things that affect this tension is the attitudes of the general public, and here it's been more pronounced than in Europe, that the general public really don't care particularly about what the NSA is doing or what security services are doing. And also here, I think it seems more obvious that the public is prepared to cede their right to privacy to the private sector, to the commercial world, much more readily perhaps than they would in Europe, and without really worrying too much about it. So why should the public care so much to cede that right of privacy to the state if the state is acting on its behalf? And to what extent does the public think this is an important argument anyway? So I think that now we come to a very interesting period in our history of wondering whether that tension between civil rights and security is somehow malleable, somehow it changes in accordance with the threat and with the public perception of the threat and the public concern about what the state may be doing to protect it. There is a question, I guess, also whether there are rules that apply even if one side of the contest, if you like, of the fight, doesn't observe those rules. Should the other side observe them anyway? Well, of course, as civil liberties people, one would say yes, of course they should. But in terms of efficiency and efficacy, maybe one would say that perhaps they shouldn't. So I think, again, there's a question that faces the security agencies as to how to build confidence, public confidence, in their actions and how to build public confidence in their judgments, if, to a certain extent, those judgments have been questioned by the revelations of Edward Snowden. And then I guess we should ask, where does suspicion of the state originate? Why are people suspicious of the state and believing the state may do them harm as individuals? I can understand, of course, why Angela Merkel was concerned about Americans spying on her telephone calls, because she comes from a background which really didn't trust the state. The state was very intrusive indeed in East Germany. But and I'm not saying she should have trusted the American government to know her secrets, of course. She could well be upset by that. But nonetheless, there was an instinctive and visceral reaction from somebody like her, which you might not find in somebody who'd been brought up in a more tolerant society. And the question of terrorism, which dominates our lives now, of trying to prevent somebody from doing something rather than investigate who did something, also increases this element of tension almost exponentially. It's extremely difficult because you're always looking backwards, and that's why security services want to collect stuff in case it might be of value in the future. But clearly any power over the citizenry needs regulating, and it's very hard to know in advance the consequences of any technological developments, which provides greater opportunities to investigate the lives of individuals. So there has to be some sort of clear, broad guidelines and rules. And I think that, when we're all faced with that question, okay, so you're sitting in front of somebody and you know that he knows that there's a bomb going to go off in 10 minutes and it may kill a great many people. What would you do? Would you be prepared to put your values to one side to try and get that information out of him? Well, I think it's a tough question, but I think the answer is pretty clear, because after all, what the security services should be doing is protecting values. And protecting values is an absolute. It's not, well, we protect some values and not other values. And in protecting values, we have to uphold those values. And so I think the tension that naturally exists and we can all understand exists actually becomes now less obvious, less pertinent and less of a problem, because I think that generally speaking people in the security services say that ticking bomb argument is not an argument, that you don't give up ground in order to protect it. If you give it up, you no longer need to protect it, it's given up, so that you always maintain the position that you had, which is that your inquiry into the private lives of individuals can only be if there's true, proper and reasonable cause. And I think if I were joining the security service again now, I would have perhaps more awareness of that tension between the security and privacy of individuals, but I would be very much more comfortable, I think, in knowing where I would put myself. Thank you.
The term whistleblower actually comes from the sports world, where a referee blows a whistle in order to signal some type of illegal activity or foul play. But I think that, from what I understand, it was Ralph Nader in the 1970s that got credit for coining the term, talking about corporate employees who disclose to the public some illegality on the parts of their employers, things like defective car designs or environmental practices. I think that he probably didn't want to go with the traditional terms of snitch or informer, and he came up with a more marketable term. But for the most part, I'm going to stay away from talking about corporate whistleblowers and the statutory protections that they get, because their disclosures don't really involve any national security in the issues. We're really talking about government employees and employees of government contractors who, for one reason or another, feel compelled to disclose some acts of wrongdoing within the organization. And we're not talking about employees who sell information to the press or to foreign governments. That's usually called treason, not whistleblowing. Whistleblowers typically act without any feelings of need for personal gain or financial gain, but because what they're doing is in the best interests of either the country or within their own agency or department. There are really two types of whistleblowers. I think it's important to distinguish the internal whistleblower and the external whistleblower. Internal whistleblowers are ones that disclose information within their own agencies. And in fact, most federal agencies have built into them systems. All right. Systems for allowing an employee to come in and discuss concerns about the agency. And in fact, there's something called the Federal Whistleblower Protection Program that allows the creation of a confidential environment for federal employees to come in and discuss concerns about individuals, coworkers, even superiors in the agency, or some systemic problem without the feeling of a need to compromise their own positions. And that's a good thing. That works most of the time, I think, and that's the reason why, although most of the whistleblowing that goes on in the federal government is the internal type, we don't hear about it because it's handled internally and pretty effectively. The kind that we hear about is the external type of whistleblowing, where someone feels a need to go public outside their agency with information. That could be for any number of reasons. Sometimes it's because they have tried to make an internal type of complaint, but it wasn't successful for one reason or another, or sometimes it's because they're complaining about an individual or individuals or a group that is too powerful to expect any kind of result by complaining internally. And sometimes it's because they're complaining about the entire agency or some program, and complaining within the agency, it's felt, would not produce anything tangible. And then lastly, I want to distinguish, I think, between whistleblowers and leakers. Leakers are individuals who disclose classified documents. And documents means more than just paperwork. It could be obviously electronic data also, because now all you need to do is take a flash drive stick and plug it into a USB port of a computer or server, and in a matter of seconds download thousands of pages of documents. Richard mentioned Edward Snowden. He's the one that's gotten the most publicity lately, so I'll spend a few minutes talking about him. He's the NSA contractor, or actually he's an employee of a contractor for the NSA, Booz Allen Company, who leaked classified records that showed a lot of things, but the one that got the most attention was the existence of this government surveillance program. Even though I don't really think of Snowden as a whistleblower, the fact is that his leaking of classified data did have the effect of blowing the whistle on a program that no one outside the NSA knew about. That program had to do, at least the one that got the most attention, had to do with collections of huge amounts of data involving email and telephone communications by American citizens, which was analyzed, or at least the metadata was analyzed for counterterrorism purposes. That program technically was not illegal because it had been carried out with a warrant that had been obtained through something called the FISA court. FISA is the Federal Intelligence Surveillance Act, which set up a special court to handle applications made by the Department of Justice or government lawyers for emergency or secret applications for warrants. Most recently for counterterrorism purposes. But even though the program itself wasn't illegal, a lot of people were kind of shocked that email and phone calling habits were finding their way into government records. And a lot of people have questioned its constitutionality. I don't want to get into a whole thing about that program, but the Department of Justice certainly seems to have a pretty strong view that Mr. Snowden violated the Federal Espionage Act, which is a law that goes back to World War I, that's designed to prevent support of U.S. enemies during wartime, and it clearly does prohibit the leaking of classified information. On the other hand, there's a lot of people who believe that Mr. Snowden performed a public service by revealing the existence of that program. In fact, even though on its face he does appear to have violated the Espionage Act, there's a debate going on in some circles about whether he should be prosecuted. That is, if he ever comes back to the United States. He's holed up in Moscow somewhere. And even if he is prosecuted, whether he should be punished. Anyway, I'll get back to the whistleblower area, the traditional whistleblowers. But I should say the leakers tend to have the same motivation that whistleblowers do, which is to expose government wrongdoing. But there's not a lot of protection for leakers because clearly what they're doing involves illegal activity. True government whistleblowers who do not release classified data can actually play an important role in uncovering fraud or abuse or illegal activity within the government. They're particularly important, I think, in the national security field, where the executive branch's instinct is to protect sensitive data, and that can sometimes be misused to cover up government wrongdoing or wrongdoing by government officials. On the other hand, the executive branch clearly needs to have some control over national security information in order to do things like conducting foreign affairs and military operations and diplomatic relations. So that's where this tension comes between, on the one hand, an individual, federal employees, wanting to do something that he or she thinks is in the country's best interest and the government's interest in protecting the country. These are not topics that allow for easy line drawing, and many people have completely divergent but entirely legitimate views about whether any given whistleblower should be prosecuted or considered a patriot. But we're dealing with traditional values here. For example, you have the free speech clause of the First Amendment. Why shouldn't government employees who are citizens like the rest of us be entitled to the same free speech rights against government intrusion that the rest of us have? And certainly the conflict between free speech and national security has been around since the American Revolution, and you can think of posters during World War II that said "loose lips sink ships." That was clearly a restraint on free speech. The Supreme Court kind of threw cold water on the idea of protecting whistleblowers with a free speech defense. In 2006, there was a decision that effectively rendered any kind of speech by federal employees within the scope of their employment as being outside or not protected by the First Amendment. So certainly anything that a whistleblower says and that constitutes whistleblowing would fall within that category. The main justification that most whistleblowers give for their actions, and certainly what Mr. Snowden has said, as I understand, is that it's kind of a patriotic theme that's consistent with the oath of office that most federal officials take, and contractors certainly in the national security area are forced to take to support and defend the Constitution against enemies, foreign and domestic. Even putting aside the constitutional and patriotic instincts, whistleblowers also have to deal with some common law issues involving breach of contract, because they're mostly, particularly with federal contractors, they're subject to confidentiality agreements that they're asked to sign. So even if there's not a criminal penalty potential for any public disclosures, there may be some civil action that they need to worry about. In order to make sure that federal employees aren't either gagged or blocked by the executive branch or confidentiality agreements, and are actually encouraged to be open about any kind of abuses or wrongdoing within the system, Congress has acted throughout American history in coming up with various laws that protect whistleblowers and encourage them to come forward. For a long time, there was kind of a patchwork of different types of laws in different areas. But in 1989, I guess that was during the first President Bush administration, there was an enactment of something called the Whistleblower Protection Act. And I'll talk about that for a minute. I have a sore throat, so excuse me. That law provides that the government cannot take adverse actions against, there's three concepts that are important. Personnel actions against federal employees who engage in protected disclosures to designated individuals. So the personnel actions, that's the first concept, that the government can't take retribution against, or that deal with the types of retribution that are not allowed, are things like firing or demoting or transfers or pay cuts. Protected disclosures that are used in the statute has to do with the release of information that an employee reasonably believes has information about some abuse or waste or safety issues involving the public health or safety, and specified persons that are allowed to receive these types of disclosures from the whistleblowers depends on whether the information is classified or not. If it's classified, the disclosures can only be made under the statute, and therefore the employees are only protected if they're made to designated individuals like inspectors general or special committees set up. If the information is not classified, it could be produced to anyone. It could be leaked to anyone. The problem with the Whistleblower Protection Act is that it doesn't cover employees of the FBI or the CIA or the NSA or any of the intelligence agencies, which are really the ones that who have employees that would be disclosing information with national security implications. So Congress actually enacted a second piece of legislation called the Intelligence Community Whistleblower Protection Act, which does apply to those types of disclosures, but it doesn't have nearly as much teeth as the first one did, and in particular, it doesn't protect employees against retribution, such as firing. President Obama did issue a directive in 2012 that instructed agencies to avoid that type of retribution, but it's not that strong. And in fact, the head of any agency is still allowed to fire an employee if he or she feels that the employee's disclosures created some national security risk. So I'm not sure how effective that piece of legislation is. So, where does that leave you as far as balancing the need to encourage disclosure of internal problems and the need to prevent public disclosure that does involve legitimate government secrets? Sometimes there's a fine line between blowing the whistle on official wrongdoing and leaking classified information. And the threat of prosecution is very real. The Obama administration has brought more cases, more criminal cases for government leakers than any other previous administration. And I think that we're if you think about American history in terms of a pendulum swinging back and forth between national security and individual rights, different times in the history, those two values have kind of taken precedence one over the other. We're kind of at a time in our history right now where the pendulum is swinging more toward the national security area. And I think Richard kind of alluded to this, is there's somewhat of an ambivalence on the part of many people toward the idea of uncovering surveillance programs when national security is being implicated. Even with the NSA disclosure program that Edward Snowden revealed, a lot of people seem to get concerned initially about the idea that the government might be reading their emails, but that hasn't exactly translated into a groundswell of opposition to the program. But without any groundswell like that, it's probably not realistic to expect Congress to do anything about the program. And the problem with not cultivating an environment where whistleblowers feel safe to report problems is that you risk ending up overprotecting official wrongdoing or overclassifying government data that doesn't need to be classified. And when that happens, you're depriving the public from information that about their own government that they ought to have. In order to have a functioning democracy, people who are voting need to know what's going on. And obviously national security and the need for some government programs to be protected may conflict with that democratic principle, but I wonder whether it's fair to assume that government secrecy only relates to foreign affairs or foreign enemies or military operations. We ought to be concerned, I think, when someone tries to avoid any inquiry into what's going on just by using the words national security without more of an explanation, and whistleblowers help to fill that gap. So just to wrap it up, what I'm suggesting, I suppose, is that whistleblower protection is important not just to prevent retribution against the individuals who are publicizing information or going public, but it's also important to be some kind of a check against systemic abuses and to enhance public awareness. You're left with questions like, is it more patriotic to expose official wrongdoing or to just trust the government to protect information? And those are, I'm not suggesting that either one of those things is a right or a wrong answer, but just having the debate is an important thing, I think, for our democracy. So.
I was asked to talk about prosecutors, and so, suppose, for example, that Mr. Snowden were to return here or to be extradited here, and the question would then become whether to prosecute him and for what, and so forth. You then get to the issue of how the balance between, or the tension between civil liberties and national security plays out in the context of a criminal trial. And so that's my subject, and I think a little bit your subject also. And I want to focus on what I think is the key player in all this, which is the prosecutor, and some of what I see is the ethical challenge in dealing with the balance between national security and civil liberties in the context of whistleblower or leaker cases or terrorist cases or other cases where those issues are implicated. And it struck me when I sat down here that there's actually two people on this panel, Judge Gardephe and Richard Zabel, who are actually probably better qualified to talk about this than me, based on the fact that they've had both more prosecutorial experience and more recent prosecutorial experience. But nevertheless, I'm going to forge ahead. I had, by way of a footnote before I get to my point, I do have a little bit of limited but ancient experience, personal experience on these issues, because when I was a prosecutor in the aforesaid Giuliani administration, but that was a different administration, that was when he was prosecutor, I tried or had an espionage case and a terrorist case in my brief experience there. But I'm not going to tell you these stories because I realize today how ancient they are when I had lunch with 5 of my criminal law students, and every one of them was born after I was a prosecutor. And so talking about sort of the Cold War espionage case meant absolutely nothing to them. I won't repeat the stories. But the experience does inform a little bit my views. So if, for example, Snowden were brought here, you'd have the government deciding whether to prosecute him at all or to welcome him back as a hero, something I think is unlikely. And if he were prosecuted, what for, and whether he were offered a plea bargain, what the terms would be. And these are all decisions would be made by the Attorney General's office, made by prosecutors. in the government. And so they have a very powerful role. One of the Robert Jackson, when he was Attorney General of the United States before he was a Supreme Court Justice, said in a speech something like, second only to the military, prosecutors have more power than anybody else to destroy people's lives. And so the prosecutor is a very powerful figure. They're not just trial lawyers. When you watch Law and Order, they largely look like they do investigations and trials, but they have a lot of authority, including making charging decisions. And when they make these decisions, particularly, it seems to me, in a case like a leaker/whistleblower case that you talked about, they really have a lot to balance, and nothing, there's no playbook. I suppose if you were a state prosecutor and you had a murder case, it would pretty much be clear if you thought that it was intentional killing that you're going to proceed in some way with the prosecution. But it seems to me that when you're talking about national security, it's never clear how you're going to proceed, and there's a lot of stuff to balance, and the prosecutors do that. And one of the things you have to balance is not only your sense of the public's interests with regard to national security, for example, but also the individual interests of the person who is or may be a defendant. And you have an obligation, it's not just the judge's obligation, for example, to make sure that innocent people aren't convicted, that the process is a fair one. And not only that, but to make sure that the government's power is used in some kind of proportionate way, that you're not engaged in overkill. And so because of that, it's conventionally said that the prosecutor has a duty to do justice, not just to win cases. And what do justice means is it's a bit vague, and a lot gets packed in to that phrase, but it's meant to capture the idea that prosecutors as public officials are doing a lot more than conventional trial lawyers, and have a duty to ensure that cases are, prosecutions are reliable and fair. And with that come particular limitations on prosecutors, or particular rules that trial lawyers in the civil context don't have to play by, which include disclosure obligations and candor obligations. Now, you might think, if you had, for example, the Snowden case, a case that is so high profile and so much would be in the public limelight, or in any terrorism case, you'd think that prosecutors would be on their best behavior, that they might be ultra cautious to make sure that they carry out their duties in the most careful way, because unlike lots of cases, people are going to be watching. The press is going to be watching. The public's going to be watching. But the reality is that all prosecutors, no matter how well-intentioned, and no matter how well-trained, and no matter how lofty their values, and I would say, certainly from my experience in New York dealing with prosecutors, both when I was a prosecutor and dealing with them in the last 25 or 30 years, I would say certainly New York prosecutors who I dealt with are very well-intentioned, very well-trained, etc. But they're people, they're human beings, and we know that we're all subject to limitations and error-prone, and more so now in recent years than when I was a prosecutor. There's a whole body of literature from the area of the social sciences and psychology that talk about how, as human beings, we're prone to error, we're prone to biases, have all kinds of limitations that have been studied, and that you can't get around them, no matter how well-intentioned you are, really. And so I think the history of these high-profile cases, terrorism cases among them, shows that prosecutors are prone to error and have to think about how to deal with that problem. In fact, one of the very first, if not the very first, terrorism cases after September 11th was a case that turned out to be rife with error. It was a case brought in Detroit against what was announced with great fanfare by the Justice Department was a group of folks who were thought to be part of a sleeper terrorism cell. The case was called U.S. against Cabriti. A group of federal and state agents who were looking for a terrorist conducted a search of an apartment where they did not find the person they were looking for, but they found various false identification and fundamentalist Islamic literature and some drawings and some videos of, I think it was Disney World and other tourist spots. And the prosecution constructed a whole terrorist prosecution based on this stuff. And in the course of the prosecution, there were agents who testified that the drawings were of sites that were potential sites of terrorism, including a hospital in Jordan and a U.S. military base in Turkey. The agents testified that the videos of, I don't want to ask whether anyone here has ever gone to Disney World and taken photographs or done videos, but apparently in the view of the agents who testified, they were surveillance videos, and the defendants were convicted. And it was only later that the Justice Department came forth and said, we're moving to set aside the convictions. We withheld evidence that would have exonerated or tended to exonerate the individuals. There was evidence that the drawings weren't of what the agents, who were supposedly experts, testified they were of, that the videos of Disney World were just tourist videos, and so forth. And you would think that in a case that was announced, I think the prosecution was announced by the Attorney General, and so many people were involved, prosecutors and agents, that there would be great care to make sure that the prosecution was conducted fairly, but it turned out that admittedly, by the admission of the Justice Department, it wasn't, and the convictions were set aside. And wouldn't suggest at all that this is typical. I think it just illustrates the risk that can take place in any high-profile case, including particularly terrorist cases, and if we have them, whistleblower cases, espionage cases, etc. Nowadays, even in garden variety cases, the defense bar and others have been arguing that prosecutors are prone to error, if not intentional misconduct, particularly when it comes to disclosing evidence in the prosecution's file that prosecutors have a duty to turn over because, among other things, it might tend to show that the defendant is innocent. A judge, a very prominent judge in California, an appellate judge named Kaczynski, recently wrote an opinion where he said that violations of prosecutors' disclosure obligation are epidemic. I don't necessarily share that view, but it reflects, I think, the increasing understanding that we have, and I think the Justice Department understands as well, at least of the risk that prosecutors are going to, whether it's error or intentional misconduct, I think in most cases it tends to be error, not disclose evidence that they have a duty to disclose in order to give the defendant a fair trial. And I would suggest that, and now I do draw a little bit on my experience, that particularly in the kinds of cases we're talking about where national security is at stake, there's a particular risk that prosecutors are going to goof up, notwithstanding their best intentions. And one of the reasons, and this gets to your earlier talk, is because of the secrecy that surrounds all the stuff we're talking about. So if you were to prosecute Snowden, for example, I assume that the government would take the position that much of what he knows and much of the evidence and much of other stuff that may be relevant is going to be classified. It's going to be stuff that was stamped top secret and classified. And the agents who would be the source of this information, which might be information that has to be disclosed to the defense, are going to be agencies that are, by training, are trying to keep secrets, not make disclosures to criminal defendants. The NSA or the CIA or the FBI counterintelligence agents or whoever is involved are all about keeping information secret. They're not about disclosing information to criminal defendants in order to enable them to get a fair trial. And so I think one of the experiences that the Justice Department has had is the difficulty, even in a garden variety case, of getting from federal investigators information that they need to see in order to comply with their disclosure obligations. And it's got to be exponentially more difficult when you're dealing with these kinds of agencies. I, in one of my cases, had a witness who was from the CIA who went by the name of Brown. And I once kiddingly said, "Is that really your name?" And he said, "Well, actually, it's Smith." And I have to say, to this very day, I have no idea whether he was pulling my leg or not. How would I possibly know? You're completely at the mercy of these agencies. No agency like the NSA is going to let a prosecutor rummage through their files, or the CIA or the FBI for that matter. And so it's very difficult. Now, you might think, well, it's an adversary process, and it's the job of defense attorneys, and let them, play their role and try to gather evidence, etc. But even in a garden variety criminal prosecution, much of the evidence is going to be in the possession of the prosecutors or their agents, and defense attorneys don't have equal access. They don't have Foreign Intelligence Surveillance Act wiretap capabilities. They don't have grand juries. They don't have access, probably in a lot of these cases, if they're appointed counsel, they don't have unlimited funds to fly overseas to talk to people who may have evidence. They don't have unlimited access to resources to talk to witnesses in the U.S. If you're talking about a classified information case, the defense attorney is going to have to get security clearance, and if they want to then look at evidence turned over by the prosecutor, they're going to have to do it in some airless skiff, I think it's called. They're not going to be able to share it with too many other people except those who have classified information. It's very difficult. Now, they may or may not be experienced in this area. The Justice Department has all the experience in the world in doing cases involving classified information. The FBI has agents with all the experience in the world. Individual defense attorneys don't have the ability to accumulate that kind of experience. They don't have resources, they don't have experience, they don't have access. And so if you want a fair trial in these cases, you're more dependent than in any other kind of case on the prosecutor to give you the fair trial. And prosecutors, I think, by virtue of the fact that they're human, they want to win, they want to do well, they are subject to all the cognitive biases that everybody else is. They have a real challenge. And so what's the punchline? I'm not really sure what it is. I think judges in these cases, more than other cases, have some role to ensure fair process. I think prosecutors, more than in other cases, have to create internal processes to make sure, as check against their own limitations, I guess. I think that the people as high up as possible in the Justice Department have to make sure that agencies do what they're obligated to do in terms of making the kinds of disclosures they need to make. But I think it's a real challenge. Recently, I just got a book today sent to me by a lawyer named Rob Carey, who's at a prominent firm that does a lot of criminal cases called Williams and Connolly in Washington. And they represented a U.S. Senator, Ted Stevens, in a case, corruption case. And he was convicted some years ago, and it was obviously very high-profile cases. There's only 100 senators, I think, and so prosecutions of U.S. senators don't happen all that often. And it was only, again, after a jury returned a verdict of guilty that the government, the Justice Department, disclosed that evidence that should have been turned over to the defense that would have tended to suggest the innocence of Senator Stevens was not turned over. Bob Carey was one of the defense lawyers, and he just published this book about the case and about his experience. And that was a case where the lawyers had a lot of money, they had a lot of resources, they were among the best criminal defense lawyers in the galaxy, and they didn't find this evidence. Their advocacy didn't get this evidence turned over until after the conviction. So I guess my punchline is simply that these cases pose a challenge in terms of striking the right balance between civil liberties and national security, and that prosecutors are really at the center of dealing with that challenge.
It's always a pleasure to be associated with a topic for which people hate America. So what I thought I would do is, and I do have views on the preference of trying cases in Article III courts, which are the civilian courts of the United States that you're familiar with, versus military tribunals. But I thought I would talk a little bit about how did we get to a situation where defendants were being, it was being debated whether they would be tried in a military tribunal or in a regular criminal court, and whether they'd be tried under the laws of war for war crimes in that military tribunal or for crimes like other defendants in a Article III court. So if you'll let me just maybe track the history a little, and I'll try to do it quickly because I know we want to have time for discussion. I think it's helpful to understand how we got here a little bit. So the history of terrorism prosecutions, and I'll focus really on Islamist extremist groups and the terrorism cases related to them. And I only do that, there certainly are other ones, I only do that because that is what truly has tested in our generation the decision of where you prosecute these cases, whether it be in military tribunals or civilian courts. And there were cases arising in the 60s and 70s, the Popular Liberation Front for Palestine and other Black September groups and other groups like that. And they were largely secular groups that led to pretty much normal criminal cases, and there wasn't much debate about that. And they were done in the criminal courts. They related to air hijackings and other cases like that. In the 1980s, there were probably three transformative things that happened that ultimately affected the United States in many ways and its willingness, how it viewed these cases as it slowly moved toward considering a military model for dealing with them. One was that there was the rise in certain parts of the world of Islamist extremism, groups like Hezbollah and Hamas, which supplanted more secular groups like the PFLP and Black September. Second, and related to that, was the rise of suicide bombings as a tactic. This was introduced, not for the first time in the world, but in this context was introduced by Hezbollah in the Middle East and later adopted by many other groups and used all over the world. And then third was the first wave of direct attacks on the United States on U.S. diplomatic and military installations between 1983 and 1984 when, as some of you will recall, Hezbollah suicide bombers drove explosive-filled trucks into the U.S. Embassy in Beirut and a U.S. Marines barracks in Beirut and the U.S. and French embassies in Kuwait. The attacks killed nearly 400 people and wounded hundreds more, and they were generally considered to have heavily influenced the decision to withdraw U.S. forces from Lebanon in 1984 and were viewed in that vein by people who wanted that to happen as quite successful. So suddenly, there are these armed attacks on U.S. government facilities, and it creeps toward a war model when, as some of these groups, and Al-Qaeda arises really under Osama bin Laden's leadership in Afghanistan, and is fighting the Soviet Union and succeeds, but because of a more extremist ideology and their views of what the world should look like, their success against the Soviets did not end what they wanted to do, and they turned their attention toward the United States. And thus in the 1990s, you begin to have Al-Qaeda training its sites, as well as other groups, on the United States in a way that's quite provocative and starts to have people questioning whether, the individuals who are caught should be tried in federal courts or whether this is really more like a war. In 1996, Osama bin Laden issues a fatwa which authorizes Muslims around the world to kill United States soldiers and some others. And then in 1998, he issues another fatwa, purported fatwa, that says it is authorized as part of jihad for Muslims around the world to kill any American. These were viewed by many people as declarations of war, and then the embassy bombings happened in 1998, the destruction of the Kenyan and Tanzanian embassies, and then the United States launched Tomahawk missile attacks against Al-Qaeda, trying to kill bin Laden in the Sudan and against training camps in Afghanistan. So this was all militarizing somewhat rapidly. In the meantime, and this is relevant to civil liberties issues, one of the frustrations for people had was with the paucity of statutes that address this conduct adequately, address terrorism conduct adequately. So and it would take too long to go through them in detail, but Congress set about enacting statutes that were much more aggressive, for lack of a better term, in terms of being able to capture terrorist conduct and try it in federal court. So what do I mean by that? Probably the best example, to use one, is the material support statutes, which some of you may have heard of. The large majority of terrorism cases have material support charges in them, and certainly the large majority have conspiracy charges in them. Both conspiracy, which has been around and is a very well-known statute, but is certainly viewed by other people around the world whose legal systems are different, as quite aggressive and all-encompassing. And it encompasses an agreement to commit an illegal act, and you can be punished for the agreement to commit an illegal act as long as someone else takes a step forward. Material support is even further back on the spectrum. It only requires that you in some way supported financially or in other ways with some expertise you have or through some conduct a terrorist group, not necessarily a terrorist act, but a terrorist group that you knew was going to commit terrorist acts or that is designated by the United States as a terrorist entity. So you're sort of pre-conspiracy in terms of the conduct that could be punished, which a lot of people questioned, and there were a lot of First Amendment challenges to the statutes when they were first enacted, and there was a lot of refining to the statutes to make sure they survived First Amendment scrutiny and didn't criminally punish just associating yourself with Hamas or Hezbollah because you believed in some of their views, which could be a First Amendment violation. So, and I want to keep on time. Then, obviously, the horrible events of 9/11 happened, and really the full pitch of stress between people's confidence in the criminal justice system for dealing with this problem and people's fear and being shaken by such a horrible incident, which is understandable, really starts to test what you believe and how you should deal with these cases and what your concept of justice is. And there's plenty of room for reasonable people to disagree about this. But in the further militarization at this point of this, criminal justice problem, after 9/11 was the authorization for the use of military force that Congress enacted that allowed the United States government, President Bush, to take military action against Al-Qaeda and all those and the Taliban and those who supported Al-Qaeda. Not uncoincidentally, at the same time, Congress set about with the Military Commissions Act and starts to say, we need military courts, we need military commissions for these cases. Why do we need them? We need them because these people, the way the argument goes, the people who commit these terrorist acts do not deserve the full panoply of constitutional rights that a criminal defendant would get. They're not criminals. They are at war with us. and they don't deserve those rights. They don't deserve an open court, the same type of open courtroom, and they don't deserve the same rules of evidence. And I say that, I'm putting their position starkly, and I don't mean that to sound critical or not. That's the fact. That's the way it was, and there were lots of people in the country who had that view and set about in a responsible way to try and create military commissions. It's not an unknown thing. Military commissions existed since before the United States. One of the first ones was John Andre. George Washington convened a military commission for John Andre, who was an American major who conspired with Benedict Arnold to turn over West Point to the British. And he was summarily hanged, and there were military commissions through the Seminole Wars and all sorts of periods in our history. They are fascinating because the law is pretty sloppy, and what happens with them is difficult. Even President Lincoln was roundly criticized in many ways for convening military commissions during the Civil War in areas where many people in Congress thought the courts were functioning adequately, and he had no right to do that. So the Military Commissions Act comes about, and the military commissions are created, and again, I am going fast through time, but they are fairly quickly and roundly found to be insufficient in a number of ways under the Constitution for people who will be tried in front of them. And they're refined, and as they're refined more and more, the military commissions really start to look more and more like Article III courts. And why is that? And that's because ultimately, even if you're prosecuted in a military commission and you're convicted, appeal will eventually have to be to the D.C. Circuit Court of Appeals. So you're going to have your conviction reviewed by the United States court, federal judges, and the Constitution applies. You can create a different building and you can put it on an island and you can have a court there, but the Constitution still is wrapped around it. And so you have to satisfy that. And if you have to satisfy the Constitution, it's not clear how much benefit you can get from creating a whole new court system. And that court system was struggling. Why were they struggling? They're very good lawyers, very good judges, but they had no history of trying these types of cases. They had no history of doing cases that involved a 10-year conspiracy with all sorts of violent acts. That was not what the military justice system was designed for, and they were doing it without any precedent. When a judge like Judge Gardephe takes the bench, who not only has tons of experience in what he's doing, he's got hundreds of years of precedent sometimes in cases he's doing to look at with judges who've thought about these issues and where the wisdom has been worked out over time. They didn't have that, and they were trying to do that. And not only were they trying to do that but they were trying to do that in a court where the Supreme Court of the United States had openly questioned whether conspiracy could be a valid law of war crime that could be litigated, could be tried, could be used as a basis for prosecution in a military court. And it also said that it did not think that material support could be used. Now, if you take away conspiracy and material support from the armory of prosecutors to prosecute criminal cases, you are in a lot of trouble. Because it's very hard to prosecute groups of terrorists if you can't charge conspiracy, or if you think it's going to be at risk of being reversed and you can't charge material support. Not to mention that all the things that were charged had to be cognizable under the law of war. So there were a lot of people who were going to Guantanamo. The idea was you're going to try them in military commissions. There were some cases that were resolved. There were some disappointing results. There were one or two results that probably people would say were good results. We could talk about those, but in the spirit of time, I won't. Only one defendant ever got sent up from Guantanamo to the United States to be tried. That was Ahmed Gailani, one of the bombers in the 1998 embassy bombings, who was tried a couple years ago by our office. Interestingly, that case, some evidence was kept out by Judge Kaplan for reasons he stated very articulately in an opinion. And Gailani, although it was a successful prosecution, he was convicted on one count out of over 230 counts. What would the world look like if that count had not been a conviction is a very, very good question. But the fact is that there's been many, many defendants since Guantanamo sort of bogged down and military commissions haven't proceeded. And the other big part of that was Khalid Sheikh Mohammed, the mastermind of 9/11, and his co-defendants were going to be tried in New York. Probably some of you remember that. There was a big hullabaloo about the security that would be required and whether that would happen. And Congress passed legislation that would not let defendants be transferred from Guantanamo without their authorizing it. A number of other obstacles arose. We were ready to try that case, and Khalid Sheikh Mohammed and his co-defendants were not transported to the Southern District of New York, and they remain in Guantanamo with no trial date, no end to the motions really in sight, and what will happen there is hard to know. Meanwhile, I think partly because, almost out of necessity, with Guantanamo not working, there have been a number of defendants since that time who've been brought into United States civilian courts, Article III courts, like our court in the Southern District of New York, and have been tried and been convicted. And that debate has died down a little bit, I think, because no one sees a viable, real alternative right now to the courts. There are a lot of people in Congress who don't like, and a lot of people in the citizenry who do not like these defendants coming into court and getting all those rights. But the fact is that no one's really got a working alternative right now. So I don't know if it was a choice in favor of rights and confidence in our justice system or a choice born of necessity. So what's happened in recent times is mainly, the courts have continued to function well. There's over a 93% conviction rate around the country for terrorist defendants. And at the same time, they've given a lot of good intelligence, and many of them have cooperated with the government, and there's been a lot of useful information gathered from them. And defendants, if they're brought here, then they're generally tried. If they're not brought here, a lot of them have probably been killed with drones and other types of attacks. So that's where we are. I think that was, that's a very short version of, I think, what was one of the signal debates of our time, what you believe in, where people should be tried. And it's not necessarily only one answer. It's not necessarily true, and I don't necessarily think that there's no case that can be tried in a military commission. There are cases that happen on active battlefields where military personnel are involved that probably appropriately could be tried in military commission. So I'm not really, I'm not trying to diminish one versus the other, but it is an important choice and an important debate to maintain about how you feel about our justice system and when people should go into Article III courts and get the rights of a defendant versus when they should go into some other tribunal, which I'm not sure we have working yet anyway.
The rights to privacy, the rights to be left alone, the rights not to have our government intrude on our personal information. Having lived both in the United Kingdom and in America, are the views different or are they the same? And if so, why?
I think that's a hard question to answer, but anecdotally, I think that they are different. Yeah, I think that here, given the traditions of the United States, given the strength of the Constitution, the First Amendment in particular, that there is, as people grow up, as people go through their education, this understanding that they have individual rights, which of course exist in the United Kingdom as well, but in a different way. It's sort of assumed that you have them rather than taught that you have them. And so I think that awareness of individual rights is stronger in this country for many historical reasons, but particularly because you have the Constitution, than it is in the United Kingdom where we don't have a Constitution. The impact of that, though, I'm not sure. I think inevitably people are protective of their privacy to equal measure in both the United Kingdom and in the United States, because we live in liberal societies which now have a long history of the government itself being held to account not only through elections but also through legal processes and so on. So ultimately, I think that the values that are enshrined here in your Constitution and so much a part of American life are very similar to the values of life in the United Kingdom, but I think that here it's more evident and obvious than in the UK.
You also suggested at some point in your remarks that maybe there was less concern now than there may have been years ago about the government collecting information about us. And I wanted to ask you whether the growth of social media, where people of information that when we were growing up, we would have thought of as very personal in nature. They voluntarily posted on the internet, disclose all kinds of details about themselves. Whether that has played a role in people's attitudes about how much information the government should be collecting about us. What do you think?
Well, I think most certainly social media has had a tremendous impact, of course, and I think that people, particularly when they're young, do give up an awful lot of information about themselves because there's an intimacy about communication on the internet which is completely at odds with the actual fact of communication on the internet, which is one of the most open ways to communicate that you could possibly think of. But nonetheless, if you're in an email exchange or messaging exchange or something with somebody, you have this impression somehow that it is private and just between the two of you. And I think because of the immediacy of that communication also, you don't consider perhaps at greater length and at greater depth what are the consequences of the things that you're saying and posting. I think also the issue sort of melds into the government role in storing information because, first of all, if you don't value your own information yourself, then why would you think that a government shouldn't be accessing it as well? But nonetheless, you expect the government to protect the information that they have about yourself, whether it's social security or whether your criminal record or whatever it might be, insofar as it's held by government rather than becoming public. But in the world that we live in now of instant communication and 24/7 sort of news cycles, people are so aware of what's going on around them. Not everything, of course, but for example, I remember there was an NBC poll the other day about awareness of the murder of the journalist Jim Foley by the Islamic State, which the pollsters found 94% of respondents were aware of that. Now, 94% awareness of any news event is absolutely extraordinarily high and far higher, according to those pollsters, than anything they'd ever come across before. Well, I think that was in the last 5 years that they've been conducting such polls. And the power of terrorism, therefore, that sort of visceral image that sears into people's minds and gets spread around, I think gives people a great deal higher tolerance for government storage of information about anything and everything, so long as they can protect people from a similar fate. Well, the risk of any individual in the, 260 million odd citizens of the United States of suffering a similar fate to Jim Foley is, of course, probably about, well, let's include some other hostages, but it's very, very small indeed. But nonetheless, there's because of the power of those images, there's a concern, a very widespread concern, which allows the government, I think, much more latitude than it would have without that sort of thing going on.
And finally, I wanted to ask you, as someone who has been involved in the intelligence world, whether there's such a thing as too much information. You made the point that most intelligence agencies want to have as much information as they possibly can, but I wonder whether when we look at the events of 9/11 and the lead up to that, what we knew about some of the co-conspirators, whether the problem was not having the information or not being able to analyze the information that we already had, and whether the desire to vacuum up as much information as we possibly can about everybody ultimately can become counterproductive in terms of the intelligence effort.
Yeah, I think you're absolutely right on that, and I think it's a very perceptive comment. You can certainly have far too much information, and with the amount of information being collected every year, probably equal to all the information that's ever been collected before, you can see the exponential problem, the volume problem created by that is just quite extraordinary and quite beyond the analytical capabilities of any organization, however big, because an analyst can only look at a certain amount of information. They're limited by their mental capacity and by time. And all this information is coming in at the same volume. So there's no sieving, there's no filtering of the information by category of value, of the credibility of the source or the relevance of the information or whatever. And that makes it a hugely difficult problem for analysts. And I think that an honest intelligence officer would admit that if you were a careful reader of the media, follower of events and so on, and you had a decent ability to analyze stuff that you came across, you could reach similar conclusions to the conclusions reached by intelligence officers who have access to far more information, because in fact what you're doing by watching the news or reading the newspapers or just thinking about things generally, you're applying filters and you're benefiting from filters applied by other people to cut down all that information into the most valuable parts, whereas the analyst just facing endless amounts of stuff, just tapping in particular criteria and getting just reams and reams of information, then has to sort of filter down, and may of course be missing some of the key questions that he should be asking.
Jeff, I wanted to follow up on a point you made in passing, which was that there have been a lot more leak prosecutions under this administration than what we've seen in the past. I was wondering if you have any insight as to why that is true, why this administration has been more aggressive about prosecuting leak cases than others in the past. I can remember many incidents earlier in history where information was leaked and investigations were conducted, and generally they came to nothing. Most leak investigations ultimately led nowhere. But more recently, we've seen, I think, more serious efforts to prosecute leakers criminally. And it raises the obvious question, why? Why are we making more serious efforts now to prosecute people for leaking information? Any thoughts on that?
Well, I think there's a lot of factors that go into why that might be the case. I mean, statistically, it's a fact that there have been more leak prosecutions during the Obama administration. It's possible that there's more leaking going on, and that could be an answer. Certainly, as our media has gotten, in my opinion, more aggressive about investigating or looking into salacious details about government programs, there's a greater temptation on the part of government employees, federal employees, to work with the press. But it's also possible that that this administration has taken a philosophical view that classified information should be protected at all costs. I don't pretend to know the exact answer to what it is, but I do think it's a complicated question.
Bruce, I wanted to follow up on some remarks that you made about prosecuting cases that involve classified information and working with intelligence agencies like the CIA or the intelligence arm of the FBI. The FBI, of course, is divided into a criminal division and an intelligence division. And intelligence agencies are about collecting information. Information is the coin of the realm. That's what they care about. Intelligence agencies are not about prosecuting people. They're about collecting information, analyzing it, and hopefully using it in a fashion that benefits our country. But when you're in the role of a prosecutor, having all the obligations that you mentioned, the disclosure obligations, the obligation to disclose exculpatory information about someone charged with a crime, what kind of conflicts does that present in dealing with agencies whose first goal is not criminal prosecution, but rather the collection, analysis, and use of information?
I think it's a challenge for a couple of reasons. If you were a prosecutor dealing with the investigative, side of the FBI, they would be used to working with prosecutors and, making disclosures and, likewise with other investigative agencies. But I don't know that there are very many, or at least maybe there are more now, but traditionally there weren't very many cases coming out of the counterintelligence agencies or the CIA or NSA or whatever. And so they won't have necessarily a well-established practice of working with prosecutors and of accumulating the information, turning it over to prosecutors. And the prosecutor has to get an understanding of how that, say the counterintelligence folks gather information, how they store it, what kinds of things they might have so that you could ask the right questions. And none of them are put on earth to make your life easy. That was, it may be different now. That was my experience, at least, that they viewed their job as avoiding disclosure of things that they had gathered. That was, you raised the issue of too much information. My limited experience was that even people within that unit who were had security clearance couldn't necessarily get access to information because everything was need to know. So if they're not going to provide stuff to other counterintelligence agents because they didn't have a need to know, they're certainly not going to provide it to prosecutors without a lot of, angst and battle and stuff. So I don't know if at this point, maybe you would know, the Justice Department has created some relationship with counterintelligence agencies to facilitate information gatherings that you could turn it over. And also, you have to understand the case and you have to understand the potential defense because, in order to figure out what's potentially exculpatory and where to find it, you have to think like a defense lawyer in a kind of case that you probably never prosecuted yourself, much less defended yourself, and then figure out where that stuff could be. So it's not like in a criminal case where there's a bank robbery and the detectives go out and they talk to people and everything is contained in a file. I can't imagine that in a espionage case or terrorism case or whatever, there's a file. Actually there are no files anymore because they're all electronic, but even in some notional way that there's an electronic file that contains everything. So the universe is infinite of stuff. You don't know where to find it. You don't know what to ask for because you don't know the defense theory unless the counterintelligence people have clued you in on this stuff, which they have no incentive to do. So I kind of wonder how you actually comply with your obligations. I'd be interested in the thoughts of anybody who's had this experience and is allowed to talk about it.
Well, Rich, I think that brings us to you.
Yeah, it's a rough end of the table to be at.
And the question is, there have been a number of terrorism prosecutions in the Southern District of New York, and many of which I'm sure, or probably all of which have involved classified information to some extent. So the question is, how do the prosecutors that are responsible for bringing these cases, trying these cases, how do they satisfy their disclosure obligations? And for those of you that don't know, federal prosecutors have an obligation under a case called Brady to turn over to the defense exculpatory information. And under a case called Giglio, they have an obligation to turn over information that would cast doubt on the credibility of a government witness. So in any case that goes to trial, the government, as a routine matter, turns over information to the defense that's exculpatory in nature, and that also casts doubt on the credibility of its witnesses. And in a regular criminal case, that's not always a completely straightforward process, but it's fairly straightforward in that the prosecutor is well situated to understand what's exculpatory. The prosecutor has ready access to all the reports that were prepared by the investigative agency, as well as ready access to all the agents and police officers that were involved in the investigation. And so the prosecutor is generally well situated to make sure that any exculpatory information, any information that casts doubt on the credibility or reliability of government witnesses is turned over. And the question, Rich, is how does that work in a setting where some or much of the information might be classified in nature? How does that whole disclosure obligation function in that context, practically speaking?
I guess I'll break it up into two parts. One is, how do you find the materials that you need to disclose? And then if it's classified, how do you go about getting that disclosed? Because even if you give that to the defense, there's the issue of it being classified and what you can do with it or not. So it's a difficult process. As the judge said, you know, in most normal cases, you have access, you're working with the FBI and maybe some New York police folks, and they have a certain finite amount of information and files and finite number of people who are involved, and you search that, you scour that for all the information you're required to turn over, whether it's just material you need to turn over under the rules of discovery, as we call them, or whether it's this exculpatory Brady material, which is, you know, among the most sacrosanct of prosecutors' obligations, is to make sure that you turn over the possibly exculpatory material to the defendant and his counsel. We have to do things called prudential searches in these cases, where we're working with the intelligence agencies of the United States, or branches in the United States. And it gets even more complicated than that, because we have liaisons and we talk to them and we say, where would this information be and how do you keep it? And, you know, they may do an initial search, and then we have to instruct them as to what would constitute possibly exculpatory or giglio information, because they have people, lawyers there, who are trained in this too, that interface with us to do it, but we like to make sure we get a look at it ourselves and do it. But it can get more complicated than that, because you know, there may be information that they've gotten. There's so much information, and there may be just some. I mean, I remember one case we had where there was a telex from the source of an ISI officer, which is a Pakistani security service, who made a ridiculous but arguably exculpatory statement about a defendant. And, you know, we found it was like finding literally a pebble in a mountain of rubble. We turned it over, and we had to, but it was, you know, we couldn't even check it out. We couldn't even go back to the original source, who was someone in the mountains of Pakistan, or to the ISI, to, you know, or in any way. So it's a difficult process, and the key thing is just finding out where would the information be. and whatever it is, how many ever gigabytes it is, and getting through it in the right way. And then, so that's how you find it. I mean, there's really not much. It's a prudential search where we rely on the other agencies to tell us where this information would be located. We ask them a lot of questions. They search it. We search it. Sometimes they won't let us search it, and they do the search, and we're telling the court how that's happening. Now, the defense lawyers you talk about then the second part of this, the classified information. If a defense lawyer, for anyone to see classified information, including a judge, they have to be cleared, be security cleared to see it. So you might turn over information that was classified, and there's a statute. It's a fairly good statute. It could be updated, called SIPA, the Classified Information Procedures Act. So when you hear about classified information and the way things are getting worked out in court, it's under that statute. And there are procedures for having hearings in front of the judge. And if there's something that the defense wants to use, and the government's saying, well, you can't use that, it's classified, that can't come out in a public courtroom, then they have to work out with either on their own or eventually with the judge some way in which it can be disclosed, or even some form of substitute information that satisfies the defense that it's getting the equivalent of what it wanted, that doesn't jeopardize the classified nature of the information. So that's something that a lot of citizens don't think about. It's going on all the time. In some ways, parts of these trials are closed to the public to some extent, or they are, that might be saying it slightly too strongly, but the original information in its most authentic form is not necessarily being used in the trial. Not for any evil purposes, but because there are national security issues at stake, and you're trying to, along with the judge and the defense counsel, reach some sort of accommodation where national security interests can be reconciled with the needs of the defendant. And if the government can't do that, if there's no substitute or no way to do that, then the government can be penalized. And the judge can decide what the appropriate penalty is, which can be even as much as striking the indictment, meaning essentially getting rid of the case. So there's a real balancing effort going on. But those are the two stages. It's really a broad, big search, working with the intelligence agencies, and then it's working it out under the Classified Information Procedures Act, if we're talking about classified information, which I think your question was.
Could you also just sort of bring us up to speed on what's going on with the military commissions? Because, as you mentioned, several years ago, there was a lot of talk about bringing people to New York City, to Manhattan, for prosecution, for civilian trial. And as you pointed out, that was made practically impossible due to congressional action. But we're now in 2014, we're 13 years down the road from 9/11. And so what is the status of the military commissions? What's going on down in Guantanamo? What's the current status? Are there ongoing cases, and what's taking so long?
There are ongoing cases. There are hearings and proceedings that happen in a I think it's fair to say, much more haphazard way than would ever happen in your courtroom or any other courtroom. I mean, in a United States courtroom, in a district court in Southern District of New York, the judge says, we're going to have our pretrial motions are due on this date. We're going to have a hearing on those motions on this date. We're going to do X, Y, and Z, and I'm setting a trial for this date. And while that can sometimes get pushed a little bit for good reasons, sometimes it won't be pushed, things happen quickly. Mr. Gailani, who I spoke about, the only defendant ever brought up from Guantanamo, was brought up in June of 2009, and he was tried a year later. His trial took place, which was a massive event, the embassy bombings, took place within a year. We've had several terrorism trials of defendants that it took us a long time to extradite, actually from the United Kingdom, that happened very quickly. They were extradited, not much more than a year and a half ago, and two of them have been tried. One was Abu Hamza, who was an imam in the Finsbury Mosque in London, and another was, he was not extradited, but he was brought from another country, Suleiman Abu Ghaith, who was bin Laden's son-in-law. So things move quickly, as you know, and as you can make happen in the United States District Court, because everyone knows what the motions are, everyone knows what the legal arguments generally are, there's some unusual things, and everyone knows how to proceed. They're trying down in Guantanamo, but a good example is when KSM offered to plead guilty at one point early on down there. they didn't receive the plea. They didn't know whether they could take the plea because they didn't know whether they could enforce the death penalty with a plea. And so they refused to take the plea. And this goes back to my point earlier. They're dealing with motions and issues that they've never dealt with in the military justice system. And the military justice system was designed for military defendants. And actually, in many ways, it's much more lenient than our justice system because it was always designed to have a military defendant on the other side, and you have military jurors and a military judge. And so the system was sort of all for people of one profession and one piece in some ways. So when they get the motions that are being brought about what was a defendant's treatment in a detention site abroad and whether he's competent to stand trial, whether he's been accorded all his discovery rights, whether certain evidence is admissible or not, whether he can be prosecuted under certain statute in which the charges were brought under a statute that did not necessarily exist in its present form at the time he committed the conduct, which is, some of you have probably heard of the idea of ex post facto laws under the Constitution, but which are a little less well defined in the military context. There's the issues are no simpler because they're down there. The problem is they don't have any history of dealing with them, any precedents. The judges are not trained that way. They're very fine lawyers. And so that's what they're just kind of, I don't want to sound flip, but they're milling around litigating things and not really getting anywhere. And the whole thought was you'd take all these people down to Guantanamo and everyone would be tried really quickly and the defense wouldn't make a fuss and you get these big sentences. And frankly, the few people who've been tried, the sentences have been much lighter than they would be in a federal court in the United States, which is partly a function of the military system and the way it works and the way military juries treat defendants. So that's the answer. It's not really a pretty answer. They're trying very hard, but there's no trial date set for Khalid Sheikh Mohammed. And as you know, as people should know, the longer you take for any trial, the harder it is to do the trial. Witnesses die, memories fade, evidence disappears, statutes of limitations arguably run if it's the government's fault that you're delayed, and you just make everything harder.